Well, good morning, everybody. This is the matter of FitLife Equipment Hire and Go Fitness. I'll ask Council to announce their appearances.
Thank you. Good morning, Your Honour. My name is Amar, initial C, and appearing with me as my junior counsel is Jones, initial S, and we appear on behalf of FitLife Equipment Hire Limited, the plaintiff in these proceedings. Thank you.
Ms. Levitt.
Oh, sorry. My name is Kate Levitt. I appear for the defendant in these proceedings, Go Fitness Pty Ltd. And appearing with me is Roger. Thank you.
Thank you, Your Honour. This case involves a dispute relating to a contract for the hire of gymnasium equipment. The plaintiff delivered the equipment according to the amended date that was agreed to between the defendant and the plaintiff. However, the defendant refused to accept delivery on this date. Accordingly, the plaintiff has 3 submissions to make today. Firstly, the contract was validly terminated by the plaintiff due to the repudiation of the defendant. Secondly, and in the alternative, if the contract was not validly terminated, the plaintiff should be entitled to damages as a result of the defendant's breach of contract. And thirdly, there is no vitiating factor relevant to this case, as the plaintiff did not engage in misrepresentation or misleading or deceptive conduct. I will submit that the contract has been validly terminated, and the alternative submission, which is that the plaintiff should be entitled to damages. My learned junior will continue to make submissions as to why this contract was not vitiated by any misrepresentation or misleading or deceptive conduct. Would it assist the court for me to provide a brief summary of the facts?
No, thank you.
In that case, Your Honour, I will now turn to my first submission. That is that the plaintiff validly terminated the contract. This termination was valid because the defendant repudiated the contract, and this repudiation occurred either by the email that was sent to the plaintiff from the defendant, or by the fact that the defendant refused to accept delivery on the 26th of November 2010. Now, repudiation occurs where one party evinces an intention or a lack of willingness to perform their contractual obligation.
What is the authority for that proposition?
Your Honour, the authority is Compatu Local Aboriginal Land Council and Sandpine, which was a 2007 decision reported in volume 233 of the Commonwealth Law Reports, page 115, specifically at page 135. Now, this citation is provided in page 3 of our outline of submissions at paragraph 12.
Are the facts of that case comparable to the facts of this case?
Your Honour, they are not. In Compatu, a joint venture was established between a land council and a corporation. Now, the corporation was to undertake certain activities with respect to the development of land that was owned by the land council. The question for the High Court in that case was whether or not a failure to keep books of account amounted to repudiation. It is the broad principle from that case that is what the plaintiff relies upon here today. Now, it is clear that applying the principle from Compatu, the failure of the defendant to accept delivery of the goods on the date agreed to between the parties evinces a lack of intention to continue their contractual obligations. Now, turning to my second submission, which is made in the alternative, if the court finds that the contract was not validly terminated, the plaintiff should be entitled to damages as a result of the defendant's breach of contract. Now, concluding my submissions here today, the plaintiff was entitled to terminate the contract and validly did so, and in the alternative, if the contract was not validly terminated, the plaintiff should be entitled to damages as a result of the defendant's breach of contract. I will now hand over to my learned junior to conclude the submissions on behalf of the plaintiff today. Thank you.
May it please the court, I have one submission to make today. The plaintiff submits that the contract was not vitiated by misrepresentation or by misleading or deceptive conduct.
What exactly is the misrepresentation on which you rely?
The defendant argues that the statement made in the brochure stating that the treadmill was the latest and the best was a misrepresentation of the facts and that it was misleading. However, we submit that this statement is not an actionable form of misrepresentation. For the defendant to establish misrepresentation, 3 elements must be satisfied, and we submit that the first and the third of these elements are not satisfied on the facts. We do concede that the statement was made to induce entry into this contract, and in fact that it did induce entry into the contract. However, this statement was not one of fact, and it was not one that a reasonable person would place any weight upon. The statement was made in the nature of sales talk, a form of exaggerated puffery, one that no reasonable person would give any weight to. Now, although the statement later became untrue before the conclusion of the contract, there was no duty to correct this, as we accept is required in some cases, such as Jones and Dumbrell in 1881, the Victorian Reports, page 199. In any event, the brochure contained a disclaimer. Liability for misrepresentation may certainly be disclaimed, especially in instances where that misrepresentation is not negligent or fraudulent. This disclaimer here stated that prospective lessees should make their own inquiries into the product. Similarly, the statement in the brochure was not misleading or deceptive. This is for similar reasons. First, that the nature of the statement was puffery.
I'm interested in how this case relates to Butcher and Lachlan Elder Real Estate.
We rely on it. There, the High Court held that disclaimers of this kind were relevant in determining whether a statement was misleading within the meaning of Section 52.
The facts there were very different, weren't they?
They were. The information there was derived from a third party rather than from the defendant themselves. However,
how does that fact impact here?
The wording of the disclaimer in both this case and the Butcher case were very similar.
That is not the issue, though.
Your Honour, our submission is that, considered objectively, a reasonable person would not have been misled by the statement made.
Who do you say is responsible for the statement in the brochure?
The plaintiff. However,
then Butcher is irrelevant.
Your Honour, we rely on that case to show that a disclaimer is extremely relevant in determining whether a statement was misleading. In any event, the wording used here was puffery, and in Overlook Management and Foxtel Management 2002 of the Australian Contracts Reports, volume 90-143, at paragraph 118, Justice Barrett stated that a certain amount of hyperbole is permissible and to be expected in business without attracting legal sanctions.
Your time is expired.
May I have 1 minute to conclude, Your Honour?
Quickly, less than a minute, please.
In conclusion, today, my learned senior and I have submitted, first, that the contract was validly terminated. Second, and in the alternate, we submit that the plaintiff is entitled to recover damages as a result of the defendant's breach. And third, we submit that the contract is not vitiated by misrepresentation or by misleading or deceptive conduct. May it please the Court, these are the submissions of the plaintiff, and we thank the Court for its time.
Yes, whenever you're ready.
Thanks, Judge. Just give me a minute. This is about a contract. There was no breach, not by the defendant anyway, no repudiation, and if there was no repudiation or any breach, then damages are not claimable. We disagree with what they just said. This is really a case about fairness, and what happened was really unfair to the defendants. Repudiation. There was no repudiation. The date for delivery in the contract was not changed in a way that changes the obligations the parties agreed upon. Rather, there was breach of contract by the plaintiff. The contract stated delivery on the 25th of October. Instead, the plaintiff delivered on the 26th of November. November. This is a breach. Worse, of a condition. Luna Park versus Tramways Advertising, 1938, 38 SR, New South Wales, 632. That gives a right to the defendant to terminate, not the plaintiff. Also a right to damages. There's nothing on our side to entitle them to rescind or to...
What is that? Rescission? On what basis are you arguing rescission?
What? I don't understand you.
If you're arguing rescission, there must be a legal basis for it. I see in your outline that you refer to misrepresentation.
Oh, right. My partner's talking about that.
I'm asking you about it now.
Sorry, I don't know anything about that. It's in his talk, and he will talk about it next. Actually, he talks about it at the end of his speech.
No, it's at the beginning actually.
Well, it isn't my part. I'm not saying rescission, I'm talking about repudiation. They're different things.
Maybe I can help him. Rescission is due to the misrep because of the statement in the brochure.
Please take your seat. We'll hear from you in a minute. I gather that you are unable to help me on this point, so please continue.
Alternatively, if an enforceable contract is found by the courts, the full amount of damages sought by the defendant should not be awarded. The damages sought after by the plaintiff are punitive and not compensation. This is the compensation principle from Robertson versus Harmon, 1848, 1 EX 850.
What weight am I to give to this case?
Sorry? It was on the week 2 slides.
It's a decision from the mid-19th century. What court decided it?
You're confusing me.
Why should I follow it?
Carry on, please.
Thanks. As I said before, I'll be addressing misrep.
Excuse me, Mr. Allingham, could you please move to the lectern?
Sure. I'll discuss misrep first, then misleading and deceptive conduct, then unconscionability under Amadio versus CBA, and then...
What is the citation of that case?
I don't know. Amadio versus CBA, and then the TPA.
What is the relevance of unconscionability here?
Because the unfairness.
It's not a general standard of unfairness, is it?
Our case is that what happened was unfair to the defendant.
Unconscionability is not relevant on these facts. Go on with your submission on misrepresentation.
There was definitely misrep. The plaintiff said the equipment was the newest available, but they tried to dump an old model. Well, not exactly, but not the newest, which was what the brochure said, even though the delivery was late, which is what my partner just said.
What statement are you referring to?
Like I said earlier, the statement in the brochure.
That statement was true, though, when it was made.
What?
The new model did not come onto the market until a few months later, so the statement was true. How can a true statement amount to a false statement of fact?
There's a case, but we can't find the name. They have a duty to correct a statement if the statement became false after the first statement, but before the contract was made. Conclusion. We never repudiated. They did, because they delivered more than a month late, even though they knew we needed it in November.
October. It was October?
And that we relied on them to deliver in time. So they have no contractual rights against us. In our opinion, there is also no rights to damages. No misrepresentation either, because there was no new model. If you don't have any more questions, okay, what a relief. That's it. Thanks.
The corporation was to
There's a case, but we just can't find the name. They have a duty to